Once you awaken to the fact that the globalist banksters have taken over our government and trashed our Constitution, you are faced with the problem of what to do about it. For most people, this means doing nothing because people don't want to do anything illegal. This video will show that disobedience is the lawful and recommended remedy to any arbitrary, unreasonable, or unjust law based upon natural law, which is the foundation upon which our nation and Constitution were founded. Natural law provides a legal basis to resist tyranny and can be argued in court. What is natural law? Natural law is the law created by God that underlies man's inherent nature. Man-made bodies of law, such as common law and equity, must conform to natural law. And why must they conform? For the same reason you don't pour water into your gas tank or drive nails with a screwdriver. When you violate the laws of gas engines or nails, you create problems. You could even say that a gas engine has a right to gasoline and a nail a right to a hammer. Man has a right to laws in accord with his God-given nature. The nature of the right determines the governing law, and laws contrary to nature are void to the extent of the violation. Our nation and Constitution were founded upon natural law, which secured our unalienable rights. And what makes them unalienable is that they are God-given, derived from the nature of man. This is affirmed in the Declaration of Independence, which states that all men are endowed by the Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. If natural law is the foundation of our legal system, where is it? We must be able to see it. Our law was based upon the presumption of liberty. This required that, first, the law could go no further than necessary to remedy the perceived harm. Second, the law must be tailored for minimal intrusion on individual liberties. Third, absent harm, there could be no legislation. This protected the rights of individuals and society and made us a free country. Fourth, where possible, the law must harmonize diverse interests. Since man does not have divine intelligence, it is not possible to write laws that are completely in accord with natural law. The only way to minimize infringement upon the sovereign will of God or violate man's nature is to follow the necessity requirement tailored to minimize infringement upon liberties. One court explained, "The individual should be granted all the rights consistent with public safety, secured by an authorized resort to the courts for their protection against all hostile legislation, which is not required by considerations of the public health or safety. In the absence of such considerations, those rights are alike immutable. In their presence, they must alike yield." The court said that our rights were secured by an authorized resort to the courts. We lost our rights when we lost our resort to the courts. In the 1930s, the Supreme Court replaced the presumption of liberty with the presumption of constitutionality, wherein most laws were presumed to be constitutional, making Congress the judge of the constitutionality of most of its own laws, beyond review by the courts, thereby removing the requirement of necessity, changing our form of government, and destroying our liberty by allowing numerous unnecessary laws to become a pestilence upon society. What are our remedies? First, we can assert the Ninth Amendment, which states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. While the courts only recognize a few rights under the Ninth Amendment, we have numerous natural rights, meaning God-given rights, retained by the people that cannot be infringed by government, and we populate the Ninth Amendment with those rights. Another remedy to unlawful government action is First Amendment religious free exercise, whereby we follow our rights as a duty to God. Or we can follow 96 Statute 1211, wherein Congress asks us to voluntarily apply the teachings of the Bible and the Holy Scriptures. As a third remedy, we can waive our statutory rights to the protection of government in order to exercise rights protected by government protecting us. For example, if the government tries to protect us by prohibiting the consumption of raw milk, or using unapproved methods to heal incurable diseases, The buyer and seller can waive the protection of government and do what they want under contract. As the Supreme Court of Nevada in Merrimont versus Banking Board said in 1910, under this police power, it is not competent for the state to prohibit the citizen from carrying on any trade, occupation, or business that is not offensive to the community or injurious to society. The business may be regulated, but not prohibited. If the business is not harmful, the prosecution of it cannot rightfully be prohibited to one who will conduct the business in a proper and circumspect manner. No trade can be prohibited altogether unless the evil is inherent in the character of the trade. The government, under the guise of regulation, cannot prohibit or destroy. It's perfectly obvious that what has been moral, legal, and safe for the past several thousand years cannot be outlawed in our time. That a number of states regulate but do not prohibit raw milk would prove that prohibition is arbitrary and unreasonable, and thereby void under natural law. We are not wards of the government, and a buyer and seller have the right to waive the protection of government when government oversteps its bounds. In 1922, just a few years before we lost the presumption of liberty, the Supreme Court in Wolf Company versus Industrial Court said, "Freedom is the general rule and restraint the exception. The legislative authority to abridge can be justified only by exceptional circumstances." Now let's look at how natural law was described by scholars in the last several thousand years. There are 5 principles applicable to all natural laws. First, positive laws must be just. Aquinas wrote, "That which is not just seems to be no law at all, wherefore the force of the law depends on the extent of its justice. If the subjects have a government which commands unjust things, they have no obligation of obedience, unless perhaps incidentally for the sake of avoiding scandal or danger." Aquinas wrote, "That is not law which is not just." John Calvin in 1536 asserted that men can and must disobey government when they deviate from God's laws. In the case of Robin versus Hardaway in 1772, the court said, "All acts of legislature apparently contrary to natural right and justice are, in our laws and must be in the nature of things, considered as void. The laws of nature are the laws of God, whose authority can be superseded by no power on earth. A legislature must not obstruct our obedience to him, from whose punishments they cannot protect us. All human constitutions which contradict his laws, we are in conscience bound to disobey." Such have been the adjudications of our courts of justice. The second principle, positive laws must be reasonable and not arbitrary. John Adams wrote in 1774, "When kings, ministers, governors, or legislatures prostitute those powers for the purposes of oppression, they are no longer to be deemed magistrates vested with a second character, but become public enemies and ought to be resisted." John Locke wrote that whenever the legislature endeavor to reduce the people to slavery under arbitrary power, the people are thereupon absolved from further obedience. Cicero wrote that wicked and unjust statutes were anything but law, and pestilential statutes no more to deserve to be called laws than the rules of a band of robbers. The most foolish notion of all is the belief that everything is just which is found in the customs or laws of nations. Third principle, positive laws must be enacted for and serve the common good. The Reverend Samuel West in 1776 stated that whenever those who pursue measures directly destructive of the public good, they forfeit their right to obedience from the subject, they become pests of society, and the community is under the strongest obligation of duty to God and to its members to resist and oppose them, which will be so far from resisting the order of God that it will be strictly obeying his commands. Fourth principle, positive laws must treat all equally. John Locke wrote that rulers must have one rule for rich and poor, for the favorite at court and the countryman at plough. Aquinas wrote that natural law is violated by positive laws, whose weight may be unequally distributed throughout the community, even if they may be intended for the common good. Fifth principle: litigation of positive laws must exercise procedural fairness. Thomas Hobbes wrote that no man may be judge or arbiter in his own cause. The Supreme Court in Holden v. Hardy in 1898 held that there are certain immutable principles of justice which inhere in the very idea of free government. Recognizing the difficulty in defining with exactness the phrase due process of law, it is certain that these words imply conformity with natural and inherent principles of justice. In conclusion, if a law goes beyond what is necessary to remedy a perceived harm, if a law is not tailored for minimal infringement of natural rights, if a law can but does not harmonize diverse interests, we don't care what government says about it. We have a natural law tradition which recommends disobedience as the remedy to tyranny. Learn the legal theory and the art of disobedience, explained in the book The Lawful Remedy to Tyranny. Go to www.naturallawremedy.com. naturallawremedy.com. One word, for more information.